right, looks like we are going live. We're still a few minutes early, so see if we're going. All right, there we are. We're going to share. To start this out, to see if anybody rolls in here. I don't want to share to a page. I want to just share. Share. Cancel. I'm going to share it from my phone. Hey Kendra, how are you? I'm going to share this from my phone. I can't quite always figure out how to share things from the page onto. Hi Andy, how are you? Give people a chance to start rolling in. If anybody wants to share this to do a watch party, that would be good. I'm going to be bringing Kathy Bushnell on here in a minute. Kathy is a soon-to-be associate with the firm. And Kathy is one of our most experienced people with unemployment. Kathy was an administrative law judge before she went to law school. Technically, I think her title was hearing officer. And she just finished law school and took the bar exam and is awaiting her results in the next couple of weeks. Let's see, sharing this. Join us to discuss unemployment and other benefits during the pandemic. Post. All right. Yay, Kathy. Kathy, do you want to start now or do you want me to start and bring you in later? Let me turn up the volume. Pat said she was having trouble hearing me. Is everybody able to hear me okay? Kendra, can you hear me? Kathy, can you hear me? All right, Andy says she can hear me all right. So can Kendra. Okay, what time is it here? We're rolling in. We've got 8:01. We'll give a few more minutes. Kendra says she can always hear me. Yeah, it's not like I'm known for being quiet. So everybody please excuse the messy home office behind me. With our declaration yesterday, we moved our offices home really, really quickly, closed everything out. We had been working mostly remotely anyway, but we went ahead and tried to get everything shut down. So I'm doing this because we've been getting a lot of questions the last couple of days about unemployment, the Americans with Disabilities Act, and how those kinds of things will affect what's going on with the pandemic. Lots of folks are losing their jobs right now. Layoffs are happening. We've dealt with that some at our own firm, and looking at having to let people go as certain parts of our business slow down. I expect that's going to happen more and more with things as the virus spreads and more businesses are deemed to be unessential versus essential. Let's talk about that right now. Yesterday, Governor Stitt issued a safer at home, not a shelter in place order. It's not clear to me under which act he declared this safer at home. There's two different acts that apply in Oklahoma. There's the General Oklahoma Emergency Management Act that went into effect in 2003, and we usually see that come into place in lots of things like tornadoes, flooding, the normal kind of natural disasters that we experience here in Oklahoma. There's also another act that comes into play, and let me pull up the name of it here. I've got it on my phone. It is the Catastrophic Health Emergency Powers Act. It's also in Title 63. Both of these are in Title 63, and they deal with emergencies and how emergencies happened. In my opinion, Patricia Podolik and I, Patricia is another associate with our firm. She's of counsel, also does employment law and civil rights law, along with myself and Kathy. We feel like this is the more appropriate act for the governor to be acting under. We've reviewed his executive orders that have come out over the last week, and he's not made it clear which act he's declaring these emergencies under. The Catastrophic Health Emergency Act, in our opinion, is more appropriate because it is enacted specifically for dealing with viral outbreaks like what we're having right now with COVID and or the coronavirus. I'm not going to refer to it as the Chinese virus. I think that's xenophobic, and it's against the naming standards that the CDC does for naming these kinds of viruses. So I will refer to it as COVID or the coronavirus. As I understand it, just for some educational purposes, it's the coronavirus that actually we become infected with, and COVID-19 is the disease that we develop. I am not a medical professional, so if I have misstated that in any way, I'm happy for anybody to correct me on that. But so let's talk about a couple of things first. The Americans with Disabilities Act, the Family Medical Leave Act, are two big acts that apply right now with everything that we have going on. Additionally, if you're losing your job because your employer is shutting down or furloughing people, we're also talking about the Oklahoma Unemployment Security Act or Employment Security Act. You apply for unemployment benefits through the Oklahoma Employment Security Commission. And that is available online if you just Google that, or if you Google Oklahoma unemployment claims. The process is very easy for you to do online and walk through. It's step by step, and it's real, I call it idiot proof, sorry for lack of a better way to explain it. But it's real easy for anybody who's not super computer literate for working on. Hey, Carla, thank you so much. I appreciate that. So let's talk about a couple of factoids about unemployment. Unemployment, you're eligible for unemployment anytime you involuntarily lose your job, except if you lose your job for misconduct. So if you go in and you have a 3-day no call, no show, and that's a violation of your employer's policies, that's misconduct. You're going to get terminated for that, and you're not going to get unemployment. If you go into work, Oklahoma is an at-will employment state, which means you can be fired for any reason as long as it's not an illegal reason. If you go to work and your employer looks at you and goes, I don't like the color of your hair, or Rachel, I don't like the messy bun that you're wearing, and you get fired, that's not misconduct, and so you're entitled to unemployment. And so whether or not you're entitled to unemployment does not depend particularly on how long you have worked at that particular employer. It is more dependent upon a look-back period, which is the most recent 4 of 5 completed quarters, as I understand it. And Kathy will jump on here in a little bit and correct me if I'm wrong, because like I said, she is our resident expert on unemployment. But they look back to see if you have qualified. And so when you're applying, they're looking to see if you have earned at least $1,500 in the base period, which is the last 4 of 5 completed quarters, and that's somewhere between a 12 and an 18-month period. And there are lots of exceptions that we can talk about where an individual might be off on workers' compensation or other things that increase how we're looking at our look back period. But we're looking back over that. Kathy says you must work for your employer at least 15 days to file against that particular employer. So if you lose your job, you could be filing against a former employer, not just your current employer. That's a little bit complicated. And again, Kathy can jump in and explain that a little bit better. Also, generally, when looking at those quarters, looking back, you have to have earned at least 1.5 times your highest earnings in that look back quarter. So again, that is looking back, have you earned that $1,500? And in all of the other quarters, are you earning, if you earned $1,500 in quarter 2, are you earning over those 5 quarters 1.5 times that? So if that applies and you are not being terminated for misconduct, you should generally be eligible for unemployment. And again, as we're going through this, I want to remind everybody that this is general information. It's not specific legal advice, and it's not intended to replace having specific one-on-one consultations, whether it's with somebody at our firm or another firm. So again, that's the general qualifications. You are entitled to unemployment if you may be entitled to unemployment. I don't want to give anything equivocally. If you have quit your job for certain reasons. So as I said, Oklahoma is an at-will employer state, which means you can be fired for any reason except an illegal reason. Illegal reasons are race, religion, color, gender, sex, national origin, religion, genetic information, pregnancy discrimination, and the like. Hold on one second. Hey, little girl, mom's online, so can we not play the computer right now, please? Okay, go in the other room.
Can I just be quiet?
You can be quiet, but you can't make noise on the computer. Sorry, I've got my 6-year-old behind me who wants to play Minecraft, and Mr. Pig popped in here to say hello. So, he likes to give kisses, and he loves everybody. So, if your boss was sexually harassing you, and it got to be such a hostile work environment that you couldn't stand it anymore and you quit, you can and you should apply for unemployment, because you would be entitled to benefits. You're leaving because of a hostile, illegal work environment. So again, if you're discriminated against based upon health information, which is a large part of what we're talking about with the COVID crisis, that's also something that you would want to look at for applying for unemployment. So right now what we're seeing is a lot of temporary layoffs, and an employer, hold on one second, I have 3 dogs. Ray, quit, go lay down, go to bed, go to bed. Ray, good girl. Okay, so, and Ray's gonna say hello. So if your employer furloughs you for the reasons that they're shutting down because they're a non-essential employer, or their sales have gone down and so they can't afford everybody, like in our position, we have a large part of our practice is in state court, and most of our family law activities have stopped because the courts aren't handling anything but emergencies, so there's not really a need for that position right now. An employer can furlough an individual for up to 8 weeks. It's a short-term temporary layoff. And when you furlough an individual like that and you give them that 8-week return date under the Oklahoma unemployment laws, they aren't required to go out and look for another job like you are if you normally have lost your job or getting unemployment. If the temporary furlough or layoff extends past that 8 weeks, the employer has the right to apply to extend that temporary layoff so that you can continue to get those benefits, and so that employer does not lose the right to recall that employee back to work. That's very important. We don't want employers to lose key employees when they have to have temporary layoffs for reasons like a downgrade in sales, natural disasters, pandemics, which they don't teach you about planning for when you're in business school on how to run a business. I have never had to plan for that in the past, and honest to God, never thought I would ever have to plan for that, but here we are today trying to figure out how that happens. So you can furlough an employee. If you're an employee who is on a furlough, you generally have to be available to work and capable of working. So if I furlough my employee and give her an 8-week recall date, but the state courts reopen in 3 weeks and I need her back, I can call her up and say, hey, the courts are back open, we have plenty of work, I need you to come back to work. She can't say, oh, Rachel, I'm on vacation, I'm not interested in working, blah, blah, blah. If the employee does that, then they're not able and capable of working, and they're no longer eligible for their unemployment. In that case, the employee would be terminated for cause and should be ineligible for unemployment at that point. Otherwise, you bring them back. And Kathy can speak to this a little bit better than me, but I also believe the employer gets a break on the ding on their experience factor, which is how they're calculated on unemployment payments in the event that they have to do a short-term furlough and they recall that employee back. Right now, because we have a state disaster as well as a national disaster, that impact on the employer's experience rate is not being applied right now. So the experience rate is the percentage at which an employer pays on each individual's wages. And so for each employee that I employ, on the first $18,700 that I pay that individual over the course of the year, I pay a percentage of that payment into the Oklahoma Employment Security Commission's trust fund, I guess, for lack of a better word, because I don't have private unemployment insurance. You do it through the state. After they exceed that $18,700, I don't have to pay anymore. But my experience rate is based on how long I've been in business and the past number of claims. So the longer that I am in business and the least number of claims that I have, my experience rate goes down, because that means I'm not terminating people or furloughing people and putting them on unemployment. So employers often fight paying employees unemployment for the exact reason that they don't want their employer experience rate to go up, because that can last quite a while. And if you're terminating a lot of people and you're not terminating them for cause, that can cost you a lot of money if you employ a lot of people. So right now, in the pandemic, this is not impacting the employer experience rate, and this is an encouragement to go ahead and furlough those people onto unemployment if necessary. Under the Families First Coronavirus Act and then the subsequent legislation, they're also passing some benefits for employers to keep individuals on, and I'm not going to go into the package that was passed last night. I've been really busy today between shutting down our office and getting other information together for my clients, so I haven't reviewed that newest piece of legislation. I will talk to you about the Families First Coronavirus Act a little bit. But getting back to unemployment, the maximum weekly rate that you can earn while on unemployment is $539. That's paid per week. And yes, it is subject to federal and state withholding. It's just like if you were earning a paycheck where you would have to pay federal and state withholding. You have to do that on your unemployment. I do believe you have an option where you can elect not to pay that amount, but you will be subject later to it on your state and federal tax returns. So that's a personal election everybody, has to make. The maximum benefit that you get under the state unemployment in non-pandemic, non-emergency circumstances is $11,700. It's a roughly, I believe, 6-month time period where you're getting those benefits. Now, with the package that was passed last night, along with ordinary emergency declarations, we have federal unemployment benefits, which extend in times of recession and other such things. When we had the dot-com bubble, I can't remember if they did it during the swine flu epidemic, but I know they did it during Katrina, etc. They had other federal benefits allowed. Yes, Kathy confirmed you can opt in and out of having taxes withheld, and the OASC will send you a 1099. So that's some basics on unemployment. So Shauna just popped in with a question, and I have some questions that I'm going to address that people have submitted earlier. But her question was, do we have to manually enter each employee to furlough them? I was told people are getting denied unless the employer manually enters each person. Shauna, I haven't seen that. The system, the employer system for entering people for the OASC has not been working properly for the last 6 months or so as I've tried to use it. I have turned that over to my accountant because that is part of the business that I don't really like. So I'm not 100% sure on that, but what I have done, Shauna, is when I furloughed my employee because of the state court shutdown, I gave her a letter that specifically said it was related to the COVID crisis so that she could provide that to unemployment, and it specifically had a return to work date that was within 8 weeks so that she knew she could come back to work and so that she could provide that to the Employment Security Commission. Kathy might pop in and give us a little bit more specific information. Kendra, I'm sorry I missed your inquiry. If you want to text me, it's easier to get it sometimes than when they roll up on the screen. So, all right, so one of the first questions submitted tonight was, what if you are only a part-time employee or haven't been at your place of employment for the required 180 days to file when your job is shut down? Well, there's no 180-day requirement. It's a 15-day requirement for this particular, for that particular employer, and then we're talking about our 12 to 18-month look-back period. As far as being a part-time employee, if you've shut down and you're no longer earning, you should apply for benefits. What's going to happen is we're going to look at the amount of money that you've earned and whether or not you're eligible over that look-back period, and that's going to determine if you're eligible based upon the look-back period and you've earned the right amount of wages. Then we're going to talk about the amount of money that you get, and that's going to be more relative to your working part-time versus full-time. So yes, you should be able to get unemployment. Again, I can't guarantee that. So next question, are there any protections for at-risk employees or those with high-risk family members that work at a place of business deemed essential? Yes, and I'll talk about those more specifically later, but you have protections under the Americans with Disabilities Act or the Oklahoma equivalent, which is the Oklahoma Anti-Discrimination Act. The Oklahoma Anti-Discrimination Act applies to employers with less than 15 employees. The Americans with Disabilities Act applies to employers with 15 or more employers. So in my case, I have less than 15 employees, so all of my employees are subject to the Oklahoma Anti-Discrimination Act. Functionally, legally, they are the same. The damages that we as attorneys are able to require for our clients, recover for our clients are a little bit different based upon whether you're proceeding under the OADA or the ADA, but the regulations are the same. So if you have a disability, then if your employer discriminates against you, then yes, you can seek some protections. If you work and you have are at risk, or you have somebody who is at risk at home that you need to take time off to take care of, you can seek leave under the Family Medical Leave Act. And so FMLA is an interesting thing right now because we passed the Families First Corona Response Act that goes into effect on 4/1 or 4/2. That provides some benefits that aren't normally available. And basically, under ordinary non-pandemic conditions, the Family and Medical Leave Act only applies to employers who have 50 or more employees within a 75-mile radius. So it doesn't have to be at one physical location. It has to be within a radius of the particular location where that individual is seeking benefits from. And so if you need to take off to go take care of a family member or somebody else with medical needs, you can seek relief with the 50 or more under Family and Medical Leave Act. Now, the Families First Act, that goes into effect on April 1 or April 2, depending on which version and how you're calculating days. That's something brand new. Normally, you have to be at an employer for a period of 1 year to qualify for leave under the Family and Medical Leave Act. Under the new act, the Families First Act, you only have to be with your employer for 30 days. If you've been there for 30 days, you have two different options. You have one set of individuals where you can take up to 2 weeks for self-care, and then you have 10 weeks for paid leave for caring for a child who's out of school, etc. And so after we're done with this, I'm going to post some links and worksheets, informations that give a little bit more information about how all of this works. Let me see, I've got a post from one of my people. Somebody with the firm says, I've heard other attorneys say that if the company is considered essential, they won't be required to continue to pay under the Families First Corona Response Act. I absolutely disagree with that. If the Families First Act applies to you and your employee needs to take the 2 week self-care sick time, yeah, you're gonna have to pay for them. And if they need to take the time off for the 10 weeks to care for their child and the other provisions, you're going to have to pay for them. There's no opt-out provision in the Families First Act that I have found, or that any of the other lawyers that I work closely with and trust their opinion have found, that says you can opt out of paying your employees because you're, quote, an essential employee or employer. I think that is just absolutely 100% wrong. And I think anybody who tries to take that position with their employees or advise individuals in that regard is taking a huge risk and subjecting themselves to a lawsuit. But again, that's my opinion. Other people might think differently. So, next question is, my husband works at an essential business and our youngest son is immunocompromised. My husband is also high risk. He is currently on a 2 week sick leave and we're hoping that the plant will shut down, but we believe they're going to be an essential business. He's going to apply for FMLA, or FEMLA is what we call it. But they said that there was a good chance it wouldn't be accepted. If he qualifies for FEMLA, it should be accepted. And if they don't grant the FEMLA under the circumstances, that is absolutely something that, Pig. Sorry, the dog is playing under here and getting caught in my cords. That is absolutely something that you should talk to a lawyer about. The husband with his diabetes likely also has a need for accommodations under the Americans with Disabilities Act. So that's very important that you look into that as well. If it's a large employer, they'll be under the Americans with the Disabilities Act. If they're, again, 15 or under 15, it'll be the Oklahoma Anti-Discrimination Act. But either way, there'll be some benefits that are available. Next question is, are contractors to receive relief? So normally, no. Unemployment isn't something that usually applies to a contractor. So if I have an independent contractor who works for me and I say, hey, I can no longer fulfill the terms of the contract, That contractor is not going to get unemployment under my business. If that contractor has created their own LLC or corporation, then they can apply for unemployment under their LLC or corporation. Usually, though, that does not apply for temporary layoffs or temporary reductions. It has to be a business closure type of thing, and Kathy can jump in there if I need any more specifics on that. However, with the new act that was passed last night, there are some protections for the independent contractors. And again, I haven't had a chance to really read that yet, to talk to individuals. So there's that. My question that just popped up on my phone: what if your employer orders you to work where there is a shelter in place order and the employee refuses? What are the options? Well, again, if there is a shelter in place and you're a non-essential business, I think you can potentially apply for unemployment. That's going to be a case-by-case basis. If you're an essential business, then you're not really subject to the shelter-in-place requirements. So that's something that is going to have to be looked at on a very specific level. Again, we're going to have some relief under the new act that was passed last night that we have to talk about. And it's going to depend on whether or not there are accommodations available for telework and the like. So employers can't just willy-nilly do whatever they want and go, oh, there's a pandemic, we have no responsibility and liability. That's just not how it works. So Talina asked a question. Let's see. Is there any job protection for an employee that refuses to go to work at an employer that is non-essential but is refusing to close? Any suggestions on how to force a non-essential employer to comply with the state order? Well, you can, first thing is you can refuse to go to work and you can apply for unemployment, and you can argue about constructive discharge and being forced to violate a state order. It's also going to depend on where you're located and what the exact terms are of the shelter in place or safer at home order regarding things. So if your employer is a non-essential employer, you can always call the state. I would start with the Department of Health and or the Department of Labor and seek their guidance on enforcement, because that will be a good place to start. Sorry, I'm getting lots of questions on my phone here too. So Talina, I hope that answers your questions. If you want to give me some more specifics, you're welcome to PM the firm Facebook page. Andy, I'm not sure, based on working for your current employer, why you might not be getting benefits. It might be that in your look back period you're not eligible. It could be that your employer is disputing why you're being terminated or ineligible. There's a lot of information that I would need in order to give you a specific answer. Kathy says it's likely that the wages that you have in the look back period or base period aren't met, which is what I just said. So Andy, if you want to message me, the base period is the last 12 to 18 months. Okay. Question: I was kind of curious about people who are at risk and have to stay home, if they can qualify. I don't have any income, but it would be good for others to know. Well, if you don't have a job, no, you can't qualify for unemployment. If you are at risk and you need to stay home and you're working, you have to look at, again, whether you're eligible for an accommodation under the Americans with Disabilities Act or the Oklahoma Anti-Discrimination Act, or if you're subject to FEMLA. So there are some options available, but if you're not working, the only kind of relief you're going to get is whatever relief is allowed through the latest act that was passed last night. Okay, what if your hours get cut by 2/3? Can you file for partial unemployment? it's not really partial unemployment. You're either getting unemployment or you're not getting unemployment. So if you're a full-time employee, full-time is defined by the unemployment statutes as working 32 hours or more. If your hours are cut where you're under 32 hours but you're still working, you can apply for unemployment. You can earn wages while earning unemployment, and unemployment's going to do its fancy calculations that I can't give you the specifics on how they reach, and they're going to determine whether or not you're entitled to some additional wages. Additionally, I'm aware that many people have had wage cuts. And so if your employer comes in and cuts your wages, then you might be entitled to unemployment. So there's nothing under federal law that prohibits an employer from cutting your wages. I could go into work tomorrow and say, hey, sales are down, we're not bringing in money, we haven't closed a case, and so I'm going to cut everybody's wages by 50%, and yes, you still have to work 40 hours a week, and you have to do all the crazy things that I tell you, and I'm going to be your normal crazy boss. And the employees can stay or go. It's their choice, but by cutting it by that much, it's really considered a constructive discharge, and if the employee chooses to leave, they can apply for unemployment benefits, and they should be granted benefits in that case. So in that circumstance, they would apply. They would say it was a constructive discharge based upon a reduction in wages. That number is generally 15%. So if I reduced all my employees' wages by 14%, then, Kathy, you're not getting a 50% reduction, only 14%. So if it was reduced by 14%, that's not a constructive discharge, and that can happen, and there's nothing under state or federal law that prohibits me from doing that. So if your employer cuts your wages, consider the flip side to that is if you leave your job and you have a job that offers benefits, you're going to be losing those benefits. Employers don't have to continue offering you benefits. Every employer does it a little bit differently. Some take you through the end of the month. Some take you through the end of the pay period. So if you're leaving a job or you're going on to unemployment, one of the very important things to do is to figure out how your health benefits are going to be impacted. If you are terminated, unless it's for gross negligence, you are entitled to COBRA if you have benefits. And so the employer has 30 days from the date of your termination in order to give you COBRA benefits. COBRA benefits information, and then after you're provided that information, I believe there is an additional 14 days for the plan to get in contact with you. It can go up to even 60 days. The employer might stop paying your premiums, at which case when you finally do get COBRA in effect, if your plan has stopped, your benefits will be reinstated back to the date of your discharge, but you are going to be responsible for paying all of those premiums. So if you're going to go on to COBRA, you want to get that up and going as fast as you can, because COBRA tends to be very expensive if you have an employer who's been paying your health benefits, and that can be really expensive. Okay, where would an office supply store that delivers fall on this list of 90% of deliveries are to hospital or other healthcare facilities? I think that person was asking whether they are essential or non-essential. As I read the rules, infrastructure that's supporting infrastructure is considered to be a essential function, and so that would be an essential position. I will tell you, I've read the definitions of essential. I think it's as broad as you want it to be. You can really drive a truck through those provisions. I think if the governor really wanted to shut our state down, he would have defined things a lot better. Again, I think he should have made declarations under that Health Act rather than the General Emergency Act, which would have allowed a tighter shutdown, because I do think we're going to see greater infection rates, which are going to put greater strains on our hospital facilities, which is going to risk a lot of people's lives. One of my people has been out for about 2 weeks, very, very sick, experiencing symptoms consistent with COVID-19 and can't get a test. I have another friend who I went to law school with who's actually in ICU right now fighting for his life because he had to wait so long to get a test. And so I think the governor not acting under this virus or healthcare act and not tightening up what is really essential versus non-essential is huge. And I understand the need to keep our economy going. It impacts everybody's business, and not to turn this into a political discussion, but this does impact why we're talking about things. We can't bring the economy to a grinding halt. We have to find some sort of happy medium, but we also have to protect people as well. So that Healthcare Act, Emergency Healthcare Act, does allow the governor to put a lot of things in place if he would choose to do so, which I think is the right choice. So there you go. Kendra, why are liquor stores essential business? Probably because a lot of people need to drink to get through the home confinement. I mean, I don't know. I'm not a big drinker. Why are medical marijuana dispensaries considered essential businesses? Well, one, because it's medical, but two, there's probably a lot of people that need the relaxation benefits to get through. Scarberry says because Everclear kills germs. I mean, hello, if you've watched any Dr. Quinn show, we always sterilize our instruments with whatever alcohol is around. So there's that. Number 9, I just started working from home for a home health care company 3 weeks ago. I'm an administrative assistant and I'm in a high risk group. We are essential and staying open. Some people are working from home that aren't comfortable coming into the office. I can't work from home as I'm a receptionist. I was told if I have to quarantine, they will let me go into the negative on my paid leave. But if I have to isolate or just not comfortable going in every day, I can't get it. Is there relief? Would I qualify for unemployment if I choose to stay home? I handle every piece of paper that comes from nurses and aides. Okay, so that question is really, really complicated. I love you too, Kendra. So first of all, that really falls under the Families First Coronavirus Act, which will go into place in a couple of weeks. First of all, there's exceptions under that act for healthcare related employees. You're a receptionist. I don't know that you're going to fall into that exception. I understand the essential as an employer. It's a lot easier for me to allow my attorneys to work from home because we're set up for all of that to happen, but I still have to greet clients, deal with incoming mail, etc. So I had to have staff more on hand until we got some sort of order telling us that we could shut down. Now, apparently today, we're magically essential businesses again. We can argue about that. I do think lawyers are essential in many ways, but I don't think all aspects of the law are necessarily essential in this kind of a circumstance. So to answer that individual's question, I think it was a woman who submitted that. Yes, I think you can get some relief under the Families First Act. That's going to be the 1st of April when that comes into effect. You're going to have been employed 30 days by that point, and 30 days is the magic number. If you choose to stay home for unemployment, that's going to be questionable. It's going to be talking about whether or not your asthma is a disability and whether or not you are being forced out and being discriminated against because of your disability. So there's going to be lots of questions that are going to be asked there. Okay. Next question. My salon is a non-essential business. I'm self-employed and renting a booth from a landlord. What recourse do I have to recover my losses? I will have to pay booth rent for the weeks the shop is closed. Do I have resources available to me if I can no longer continue my current business? Well, a lot of that depends on whether or not you are incorporated as an LLC or a corporation, whether you've paid yourself a salary, and whether you're paying unemployment benefits or insurance into the trust fund on your behalf. as far as paying rent, there is some relief that the president has announced in terms of we're not allowing evictions and that sort of thing. It hasn't really been made clear from what I've seen, and again, I haven't read the legislation from last night yet, about how that applies to commercial businesses. That's a concern of mine. If I'm closed down and I'm not earning a lot of money coming in, I'm still going to have to pay all of my rent for my office location and all of those different things. I'm still earning some money, but it's going to be significantly reduced. So I'm not the only, you're not the only one experiencing that. There are SBA loans available. If you've been in business for a while, you're going to have tax returns, that sort of thing, that you can apply for SBA loans. Those do not apply generally to cannabis businesses, and we do a lot of work with cannabis business. It's not recognized under federal law. It's illegal under federal law, so the federal government is not going to give your cannabis business money to continue to operate. So best of luck to you there. You can look for grants and try to figure out if you're eligible for a grant that might be helpful. You need to try to work something out with your landlord as far as not paying her rents. Unfortunately, that is just a very difficult situation to give a direct answer to. Can a self-employed individual receive disaster relief or unemployment assistance? That kind of goes along with the last question. It really just depends on your situation and how you've set yourself up. Let me see. I think I've seen a couple of questions roll up through here. Oh, Matt, if I knew the answer to that, I'd be worth millions. People aren't getting tested, and I don't understand it. Kate, did I miss a question from you? I see your comments. Go back here. Oh, Kate's commenting on why liquor stores are considered essential businesses. She says because if someone goes into withdrawal, they might end up in the ER, and they are at higher risk for infection and death. Liquor stores are necessary. Same for marijuana. If a patient can't get their meds that control seizures or pains, they have to go to the ER. Absolutely, I agree on marijuana. I was partially joking on that earlier. Cannabis is used for pain control, seizure control, lots of other things. It is absolutely a medical necessity, in my opinion. Interestingly, we've talked about dispensaries being essential businesses. We've not talked about grows and processing as being essential businesses, but under the exceptions for infrastructure, which support essential businesses, I think they fall into that exception. They also fall into agricultural and manufacturing exceptions, which, as I said before, the exceptions or the definition of essential is so broad that you can really drive a truck through it. If you want something to be an essential business, it is. It can be, without a doubt. Grows are processing in many, Scarberry, I'm not quite sure I understand what you're saying there. So we have that. Next question. I actually pulled this off of EEOC guidelines. So the EEOC has some information up about the ADA and how it applies. This specific question that I thought was important was, during a pandemic, may an ADA-covered employer ask employees who do not have symptoms to disclose whether they have medical conditions that the CDC says could make them especially vulnerable to influenza complications. And so this is important because employers can't just go around asking you your medical information. That sets them up for discrimination and violations of the law. Let's be clear, an ordinary employer is not a HIPAA protected entity. And so they're not subject to HIPAA. If you tell your employer, hey, I've got HIV/AIDS or I've got asthma or whatever, and then they turn around and tell somebody else, that's not a violation of HIPAA. They're not a HIPAA entity, and so they're not covered by HIPAA protections. there might be violations of workplace privacy rules. Specifically in Oklahoma, there's a statute that makes it a misdemeanor if, as an employer, I would go around start telling everybody my client's private medical information, particularly as it relates to a communicable disease. But it's not a violation of HIPAA. HIPAA is used out of context many times in an inappropriate way. So that is not HIPAA. So going back to the question that I pulled from the EEOC, I'm going to read you what the EEOC's answer is. And the answer is no, the employer can't ask these questions. If pandemic influenza is like seasonal influenza or the H1N1 virus in the spring and summer of 2009, making disability-related inquiries or requiring medical examinations of employees without symptoms is prohibited under the ADA. However, under these conditions, employers should allow employees who experience flu-like symptoms to stay at home, which will benefit all employees, including those who may be at risk of developing complications. So, they can't make disability-related inquiries, and they should allow those individuals an accommodation of staying home. And whether it's paid or unpaid is going to depend on the availability of leave that you might have under your employer's conditions, FMLA, sick leave, PTO, that kind of thing. But your employer can't just ask about those things. So that's very important. Hold on, let me look at my notes here. Some other things that I pulled about the ADA and the EEOC is if an employee voluntarily discloses without a disability-related inquiry. So you walk in and your boss says, "Hey, Fred, how are you doing today?" And he looks at him and he says, "Oh my God, I've got the COVID. I'm going to die." He's disclosing that he has a specific medical condition. The employer must keep this information confidential. Again, talking about what we talked about. This is not a HIPAA violation. It's a violation of workplace privacy. The employer may ask him to describe the type of assistance that is needed. Telework, employers should not assume, this is very important, employers should not assume that all disabilities increase the risk of flu-like complications, as many disabilities don't increase that risk at all. Like I'm wearing glasses. Just because I wear glasses, vision and impaired vision is a disability. But the need for glasses doesn't increase the likelihood that I'm going to need something related to COVID. If the pandemic becomes severe or serious, according to the assessment of local, state, or federal public officials, then ADA-covered employers may have sufficient objective information from public health advisors to reasonably conclude that employees will face a direct threat if they contract pandemic influenza. Only in this circumstance may ADA-covered employers make disability-related inquiries or require medical examinations of asymptomatic employees to identify those at higher risk of influenza complications. So it's not coming to work or your employer takes your temperature maybe in your ear or on your forehead to determine whether or not you're exhibiting symptoms, so they can determine whether or not we're putting everybody at risk. We're doing a general medical examination, and employers are allowed to do general medical examination. They can't do these disability related inquiries. That's very important. So let's go talk about the ADA. So the ADA, the Americans with Disabilities Act, again, applies to employers with 15 or more employees. It protects applicants and employees for discrimination based on their disability. It's important in pandemic situations in three ways. It regulates the employer's disability-related inquiries, like we've already talked about, and medical examinations for all employees. including those who don't have disabilities. This is something that's done across the board. Every employee that walks in the door, we take their temperature every day. We ask them a series of questions. Are they exhibiting any of these symptoms? That's a medical exam. That's not a disability related inquiry, so that's okay. Next, the ADA prohibits covered employers from excluding individuals with disabilities for the workplace for health or safety reasons unless they pose a direct threat, i.e. a significant risk of substantial harm, even with a reasonable accommodation. Okay, so we have to talk about that. Like, you can't just say, stay home, you can't come to work unless there's a reason. I mean, if Fred has everything that indicates that he has the COVID, but Fred is like my employee and Fred can't get the test because we don't have any tests available and we only test those people who make lots of money, like basketball players, then you can tell Fred he needs to stay home. I've got my employee staying home. She's working from home. She's getting her work done as best she can. She's getting paid. That is what, one, is best for her because she needs to heal, but two, what is best for my other employees because there's no real risk to, or no real way to mitigate that risk of her transmitting this highly communicable disease among all the other employees, and that would just be hugely detrimental to my business. So I can tell her to stay home. It's not considered disability discrimination. It's not a violation of the ADA, even if I was subject to the ADA or the Oklahoma Anti-Discrimination Act. Third, the ADA acquires reasonable accommodations for individuals with disabilities absent undue hardship during a pandemic. So that doesn't mean that your employer can say, oh, but Bob, you're an essential employee, and I know you have their disability with asthma and COPD, and that's going to cause you all kinds of problems. You have to come to work and you have to sit next to Fred with the suspicious cough that we can't get diagnosed unless, like, Bob's the only one who can do that job. And then, even then, you're going to have to take all kinds of precautions. Bob is entitled to reasonable accommodations, telework, making Fred go work someplace else, doing the different things. The other thing is whether or not a viral diagnosis like coronavirus or COVID-19, the resulting disease, is something that is a disability and requires accommodation. So some diseases are a disability and require accommodation. Cancer, it's a disease. It requires an accommodation because it impacts a major life activity. But diseases that are relatively short-term and sort of the starting time period that we look at is 6 months or less, those aren't things that we consider a disability ordinarily. It usually has to be 6 months or longer. But if that disease, like the COVID, creates complications, breathing difficulties that impact major life activities, and major life activities have typically been defined as things like sitting, standing, walking, vision, hearing, speaking, those sorts of things, eating, lifting. If it impacts those major life activities, then that's something, it's a complication, then we might have a disability. Also, the newer law and court cases have talked about impacting bodily functions, and breathing is an essential bodily function. I mean, I don't know about you, but I'm not going to live very long if I can't breathe. And the thing that we know about with COVID is it substantially impacts your breathing ability. From all of the things that I've watched and read online, it almost is like it solidifies your lung. The mucus gets down deep inside and sits in your lungs, and we can't expel it like we normally do, and it thickens up inside those membranes, and it's almost like you're drowning. And again, part of what I understand is it's because we don't have any antibodies to it. Our body's immune system is like just going haywire and working overload, and it kind of triggers almost like what I understand to be an autoimmune response. An autoimmune disease happens when your body looks at something that's normal. Like my daughter has type 1 diabetes, and type 1 diabetes is an autoimmune disease. And so her body has decided to attack her pancreas, and so she no longer makes insulin, and so her immune functions just went wah and attacked the pancreas, killed it, doesn't work anymore. So what I understand with COVID that's different as opposed to other SARS viruses, and COVID does arise from a SARS virus, a coronavirus, or the common cold or influenza, is it causes these immune responses to go crazy. And so I don't know if the answer is going to be that this autoimmune functionality constitutes a bodily function that requires accommodation, and it's a disability. I anticipate we're going to see lots of litigation related to this as things go on and we see people survive and have complications. Some of the statistics that I've seen and read is that once an individual contracts this and it develops into the full blown with the lung problems, is that people are having a 20 to 30% diminished lung capacity. So I don't know if that turns into a COPD type diagnosis, but that long-term damage to your lungs from the COVID-19, that is going to be a disability, and that is going to be something that is going to require an accommodation. So things to think about. So even if it's not an ADA disability immediately, because it's a virus and it doesn't impact major life activities until you have breathing difficulties, if you're a FEMLA eligible employee, you're going to be able to get your traditional FEMLA, which is 12 weeks unpaid leave. Hey kiddo, mom's still on the internet, so I need you to be quiet, okay?
Sure.
Thank you. I love you.
You too.
I love you too.
Oh, run away. Because
Okay.
he's coming to get us.
So, you get your traditional FEMLA that you can get your 12 weeks unpaid leave, and then now we have the new FEMLA options under the Families First Coronavirus Action. And one of the things I'm still figuring out is whether or not an employee, say, because the FEMLA look back period is 1 year, and it can be calculated a couple of different ways. It can be a calendar year, it can be a fiscal year, or it can be a rolling 52-week year. So if I went out on the new FEMLA coronavirus leave on, let's say, April 15th, and my employee, baby girl, mama's still on the thing, I need you to be quiet.
Okay, I'm trying.
Thank you. So if I go out on April 15th under the new FEMLA coronavirus relief, and my company was on a fiscal year of July 1 to June 30th, and say I've already used my 12 weeks of unpaid FEMLA for maternity leave, am I now entitled to take these 10 weeks of paid leave? As I'm looking at things and as I'm talking to other individuals, I believe that you are entitled to an additional 10 weeks of this leave, plus the 2 weeks of paid sick leave. So we're still getting a lot of information. As I was preparing for this today, the Department of Labor released its guidelines, and I haven't had a chance to read through those yet, but I will post those on the firm Facebook page so that you can look at those. So we'll talk about that a little bit more, but under the act, you get 2 weeks for personal self-care. If you're ordered to quarantine or you're sick, you get 2 weeks paid leave, and I don't think that matters whether your employer is essential or unessential. If you work for somebody that has 500 or less employees, you get 2 weeks. There is the option for applying for an exception for employers with 50 or less employees, because that normally isn't subject to FEMLA. I don't know if the clarification, the Department of Labor standards that came out today clarified that, but I do believe that's going to be a very complicated thing, and I think that's going to be really, really hard on small businesses in doing that, because while the government has promised us tax relief and tax incentives, a tax relief and tax incentive doesn't give me the money today to pay my employee if I have to unexpectedly put 5 of my 9 people on a 2-week paid leave and I don't have anybody at work to generate income. That is incredibly, incredibly hard on an employer. After that, you can get 10 weeks paid leave for taking care of children that are out of school. Again, we need to look at these guidelines. If I have a 17-year-old who's out of school, or you have a 17-year-old who's out of school, do I really have to let my employee take those 10 weeks off to go be with their 17-year-old? Can their 17-year-old not sit in front of the computer and do their distance learning? It would seem not, but that's going to be a case-by-case inquiry, because maybe their 17-year-old has special needs. Maybe their 17-year-old is nonverbal. Maybe they're severely ADHD or diabetic or whatever. And so that's going to be some case-by-case inquiries that we're looking at along with the medical guidelines. Going back to the ADA, the employer cannot require a detailed medical disclosure. Your employer can't say, if you want to take ADA or FEMLA time, oh, I have to know all the details of your disease. They're just not entitled to that information. They're entitled to basic information that says you need the leave. So they're not entitled to your medical records either. Under FEMLA, your doctor is only required to tell the employer that you have a serious health condition and you can't perform the essential functions of your job. The employer can give more information, but doesn't have to. Under the ADA, they have to give reasonable accommodations. They have to get enough information to know what kind of accommodations that you need. So you might say, for instance, I have diabetes and I need frequent meal breaks, or I need frequent breaks to test my blood sugar. You don't have to say, I'm hypoglycemic and if I don't eat every 15 minutes, then I'm going to pass out at my desk and die. Like, one, you shouldn't say that anyway. But two, your employer is not entitled to all of that. All they need to know is you have a condition that requires you to need to eat more in order to keep your blood sugar up to be productive. If you have lifting or standing restrictions, again, I have a condition which limits my ability to stand for long periods of time. If I need to be on my feet to do my job, I either need a stool or I need to be able to take more frequent rest breaks, that sort of thing. Employers, again, have to treat your medical information as confidential. It can only be shared under limited circumstances. Your direct supervisor should not be getting this information if you're requesting accommodations. This should be going to HR. It's nobody's business. You need to give the minimum amount of information possible to your employer. What else? So we talked about the Families First Coronavirus Act. Again, it's 2/3 pay up to certain caps. I can post some information on the caps. I don't have them here in front of me. Genetic information, the employer can't require you to give genetic information either. So again, you have protections in these pandemic situations. If you're losing your job, you are entitled to unemployment. My understanding is with the act that has been passed last night, there is, I believe, up to an additional $400 a week available for 3 or 4 months for pandemic-related unemployment. So a lot of employees that are higher earners aren't going to be losing as much money as they would be if they had to go on to regular unemployment. There's going to be more protections in there relating to those supplements that are going to be families, that sort of thing. I'm going to post the links to the Family First Coronavirus regulations. Is there anything else anybody has a question about that I haven't covered that you would like to know? Chris, Rowdy, Dean, anybody have a question? Let's see. Oh, let's talk about that. Chris points out that N95 masks are in short supply, and the basic face masks get 72% of particulations out, which is a risk of contamination. So one of the things I've been talked about with several people is that healthcare workers are being threatened with termination if they use mask PPE. We all know, if we've paid attention to the news, we don't have the PPE available. Governor Stitt was on the news on Sunday. I don't remember what the day the latest declaration was made. All the days kind of run together anymore. Talking about the need for the sewing circles and making those masks. I have had nurses reach out to me here within Oklahoma as well as outside the state of Oklahoma, where they have been told if they wear those homemade masks or other masks, they will be fired. Okay, first of all, I will sign those cases up all day long. Universal precautions are well established about using masks to protect workers. I understand the concern of the risk, but I also understand we have people making these masks to help protect our workers. Do you understand the mass reinfection rate and spread rate we're going to have with a virus than the flu? If we have healthcare workers who are breathing in droplets, if it's aerosolized, or getting droplets in their mouth or nose if it's only in droplet form, because they don't have protective PPE. Our healthcare workers are our first line defense to taking care of this virus and keeping it from spreading. And telling healthcare workers that they can't wear a basic mask, even if it's a homemade mask, is ridiculous. It violates public policy. And in Oklahoma, if an employee is terminated from their job in violation of public policy, that's a wrongful termination kind of thing. In Oklahoma, it's called a Burke tort. And there's actually some case law on this fact that came out 4 or 5 years ago. An employee was allegedly sick with the flu, worked in an old folks home doing food prep. And the employee said he called into work because he was sick. He had a doctor's note, and his employer fired him. And so he filed a lawsuit for wrongful termination. It doesn't fall under our normal EEOC guidelines, those any reason but an illegal reason, and so it fell under this public policy exception. And the Oklahoma Supreme Court said that taking proper precautions and caring for people is a reason not to come to work, and preventing an individual from coming to work and exposing a vulnerable population to his contagious disease and firing him for that was potentially a violation of public policy and allowed that cause of action to go forward. Now, there were some facts in dispute in that case as to whether or not the employee was really a no-call, no-show, et cetera, et cetera. But the important thing is we have precedent in Oklahoma that talks about healthcare, universal precautions, and protecting vulnerable populations, and firing people who refuse to put people at risk as being a violation of public policy. So absolutely using those masks, even if they just help block those droplets from getting in our mouth and nose, that's vital. And so healthcare employers who discipline or terminate employees for using that PPE, call me, call another employment attorney. I think that is absolutely wrong, and I think those folks are going to be subject to wrongful termination or adverse employment action lawsuits. So we want all that to go around. Hi, Tim. Let's see. Pat had a question. Did I miss anything, ladies?
What?
Yes, I understand that they're afraid that the masks could have germs on them when they're brought in from a non-sterile environment. The easy solution to that is to wash them. We know that washing things in hot water helps basically sterilize it. We can show the examinations, and the biggest thing that they're telling us to stem the tide of this pandemic is washing our hands. So if washing our hands work, and please excuse my horrible manicure, because I haven't gone to go get one because I'm doing everything I can do to avoid the disease. If washing our hands is a surefire way to avoid this pandemic, then washing those masks and keeping them in proper environments is a surefire way to take care of it. I'm also not talking about using them in sterile operating fields. I'm talking about nurses using them as they're triaging individuals and dealing with all of that. So there you go. Let me see. I got one more question. Oh, I did not cover that. So one of the things I had an inquiry about today was whether or not because their significant other or other family member works in the healthcare field. No. That is association discrimination under the Americans with Disabilities Act. So discrimination under the ADA can happen in basically 3 different ways. There's actual discrimination. I'm firing you because you use a wheelchair and wheelchair employees make my business look bad. That is out and out discrimination on the basis of you being disabled. There is regarded as disability. I have HIV/AIDS, and you know I have HIV/AIDS, and I don't have anything wrong with me. I haven't asked for any accommodations. I haven't said I have a disability, but because you know I have this highly communicable disease, you look at me and think I'm a horrible person, and you don't want me in your business, so you terminate me. You're terminating me because you regard me as being disabled. That's wrong. That's illegal. And then finally, there is association with, I don't have anything wrong with me, but I have a daughter that has type 1 diabetes. And so I work for a fancy law firm, and my law firm doesn't like that I am associated with somebody who has type 1 diabetes, which is a disability, and they don't like that sometimes that means I'm not at work at 8 a.m. Or they don't like that I might have to leave to go give my kid a shot during lunch. I'm using this as a real experience because I had an employer tell me right after my daughter was diagnosed at the age of 4 that I had to choose between being a trial lawyer and, baby girl, I'm on the thing. Can you wait just a second?
Sure.
Okay, thank you. Okay, I had an employer tell me I had to choose between being a trial lawyer and being a mom to a kid with diabetes. First of all, no, I don't. But secondly, they were discriminating against me and my ability to try lawsuits because I was associated with an individual who had a disability and required an accommodation. That is absolutely illegal. So, you cannot do that if an employer, if you work for a business and they know your significant other or your child or somebody else in your household works in the healthcare facility, and they think that means you're exposed to an increased likelihood of getting coronavirus COVID-19, they cannot fire you or discipline you or tell you that you can't come to work because you're associated with that person. That would be illegal. So, any questions about any of those things? I'm checking my notes from my office people that are texting me. Yes, guys, that is an absolutely real story, and I pieced out from that law firm about 6 months thereafter because nobody was going to tell me that I couldn't take care of my daughter and try lawsuits, and I think I've successfully proved that that can be done. So, if nobody else has any questions, I'm going to let you go because the little one behind me keeps wanting to talk to me about her game thing that she's playing. I forget what the fancy they build it up thing is called. So anyway, thanks for watching, guys. Have a great night. If you have any more questions, reach out to me anytime. Bye.